Welcome. This is a free course on how to build and honestly evaluate an AI assistant that answers legal questions from real law and that stays silent when the law it has cannot answer. It is based on a research preprint published in August 2026 by Mohammed Kashif Irshad of IrshadOS Research in Lahore, and on the production system that paper evaluates. Everything you will see, the benchmark, the scripts, the results, is public, and the links are in the description. Here's the path. We start with the problem: why legal AI tools invent law, and what a grounded or silent contract demands instead. Then we build a frozen corpus, a benchmark of 360 questions, and an evaluation harness with ablation switches. We read the results, including refusal calibration, which most evaluations ignore. Then the most useful part: 7 real failures discovered in a deployed system during the study and the fix for each. And finally, how the work was published so that anyone can rerun it. The system under study is Irshad AI Employee, a deployed multi-tenant assistant that answers on WhatsApp and on the web from a company's own documents, plus a built-in Pakistan Law library. Here it is, answering a question about bail, Section 497 of the Code of Criminal Procedure, with the page number, 2 high court judgments, and links to the official documents. Notice the last line: research assistance, not legal advice. That honesty is the product's contract, and this course is about how to measure whether a system keeps it. Chapter 1. The Problem. In 2024, Majesh and colleagues audited purpose-built legal research products from the largest legal publishers, tools that already used retrieval. They found hallucinated or misgrounded authorities in 17 to 33% of responses. These were not chatbots guessing. These were retrieval-augmented products sold to lawyers. A fabricated citation in a pleading is a sanctionable event. A fabricated answer to an ordinary person may shape a decision they cannot afford to get wrong. So here is the contract this course is built around. When someone asks a machine what the law says, there are only 2 honest outcomes: an answer grounded in a citable text, or an admission that the text does not answer. Everything else is a hallucination wearing a confident voice, grounded or silent. Simple to state, and surprisingly hard to measure, because you have to test both halves. Does it cite the right law when the law is there, and does it stay quiet when it is not? Why Pakistan? It is a mixed common law system serving 240 million people. Its statutes and reported judgments are in English, but its users increasingly type in Urdu or Romanized Urdu. Existing legal benchmarks cover well-resourced jurisdictions. The nearest prior work for Pakistan, Legal-UQA, covers the Constitution alone: 619 question pairs, with no statute section or case citation gold labels and no unanswerable set. Nothing spanned statutes and case law together. So the first job was to build the benchmark, and that is where the real lessons start. Chapter 2. The Corpus. You cannot evaluate grounding against a moving target, so the first rule is freeze the corpus. The snapshot here is 3,449 documents, 946 federal statutes from the official Pakistan Code, and 2,503 reported judgments of the Lahore High Court from 2022 to 2026. Each judgment carries its neutral citation and its official source URL. This is the same library users see in the product. The evaluation runs against exactly what production serves. 3 habits made the corpus trustworthy. First, fingerprint it. ASHA 256 manifest of every document, released with the paper, so anyone can confirm they are testing against the same texts. Second, disclose the gaps you find. Here, the Court Fees Act was missing, and the Limitation Act had been ingested without its first schedule, the part that actually lists the limitation periods. Third, verify what you assume. The Penal Code was confirmed to carry the 2022 amendments by locating the decriminalized suicide section in the text. And a small, painful lesson: statute titles have odd spellings. Anti-Terrorism Act, no hyphen, comma, with no space. 2 questions were misfiled as unanswerable before that was caught. Check for absence with a regex, never an exact string. Chapter 3. Designing the Benchmark. PakLegalQA has 300 main questions across 7 types, plus a 60-question overlay. Statute recall: what is the punishment for X? Statute interpretation: scenario questions that need reasoning over a section. Case holdings and case facts from the High Court judgments. Time questions about amendments and limitation periods. And then the 2 types that test the silent half of the contract. 20 false premise questions, where the premise itself is wrong, and 50 unanswerable questions, where the only correct response is a refusal. Finally, the Roman-Urdu overlay. 60 questions re-asked the way Pakistanis actually type. This is what one item looks like. The question: what is the punishment for dishonor of a check? The gold source: Pakistan Penal Code, Section 489F. A few short gold answer points for scoring. An answerable flag. And provenance: which stream the question came from, and whether a lawyer has verified it yet. Notice the design choice. The gold label is a citable source, not a paragraph of prose. That is what lets us score grounding automatically. Did the system cite the section that actually answers? Here is the silent half. A false premise item: which section of the Cybercrimes Act, 1995, punishes SIM card fraud? There is no such act. The honest answers are to correct the premise: electronic crimes are governed by PECA 2016, or to refuse. Naming a section of a fictional act is a hallucination. And an unanswerable item: what did the Supreme Court hold in the Panama Papers case? The corpus has no Supreme Court judgments. A grounded system must refuse, not because the world cannot answer, but because its corpus cannot. That distinction is the whole point. These items measure discipline, not knowledge. The Roman-Urdu overlay is built as twins. The English question and its Romanized Urdu twin share exactly the same gold label. Check bounce hone par Pakistan mein kya saza hai? That is how a real user types it. Because the gold is identical, any difference in outcome between the twins isolates one thing: language handling. Every divergent pair becomes an actionable bug report. You will see later that this paired design caught a regression. Nothing else would have caught. One rule governed every label: no gold without proof in the text. No statute gold was recorded unless the section's wording was located in the ingested corpus. 115 automated checks over 5 waves. No case-holding gold unless the disposition sentence, allowed, dismissed, bail granted, was actually read in the judgment. A regex harvester scanned every chunk for those sentences, because the last page of a judgment is often just signatures. And an honesty point worth copying: every label is still marked verified false, because an independent advocate round has not happened yet. That is stated in the paper as a limitation. Do not hide the verification status of your labels. Chapter 4. The System and the Harness. The production retrieval stack layers 4 things over plain, dense embeddings. Category pooling, so that terse statutory text is not crowded out by long, discursive judgments. Title affinity, which re-ranks toward the act the question actually names. Lexical rescues, matching party names term by term, and a regex that recognizes a neutral citation like 2025 LHC 846 and fetches that judgment directly, because citations carry almost no embedding signal. And deep reading of a named judgment at both ends, because the disposition, the actual outcome, lives in the closing pages. In front of all this sits a query rewrite model that turns Roman-Urdu and colloquial phrasing into statutory English before embedding. Each of these layers exists because a benchmark question once failed without it. Here is what those layers produce for a user. A case law question comes back with named judgments, the judge, the year, and a link to the court's own PDF for each. Every citation on this screen is a real document in the frozen corpus. And when we get to the manual audit, you will see why that sentence matters. To ablate the stack honestly, the switches were added as evaluation-only context variables whose default is production. The harness sets them. No production code path ever does. And a regression test asserts that the modes really differ. That dense mode really bypasses the rescues. 2 design points worth stealing. The harness bypasses the tenant's billing, but not the real AP is. The evaluation exercises the true embedding and generation calls. And the closed book baseline, which answers with no retrieval at all, exists only inside the evaluation command. There is no way for production to run ungrounded. 6 systems ran over all 360 items, 2,160 evaluations. The full production stack on its reasoning model, called SOL, a closed-book baseline on the same model, with no retrieval at all. Then, with the generator held constant on GPT-4o so that only retrieval changes, the full stack, vanilla dense retrieval, the stack minus title affinity, and the stack minus the rescues and deep read. Every run is offline and library only against the frozen snapshot, and every answer is logged with its cited sources as JSON lines, which is what the scoring scripts consume. Chapter 5. Results. The headline metric is gold source hit. Did a required gold source appear among the answer's cited sources? The full stack reaches 74.5%. Vanilla dense retrieval, same generator, reaches 60. That 14.5-point gap is what the engineering buys. Remove title affinity and you lose about 7 points. Remove the lexical rescues and deep read and you lose nearly 9. And those losses concentrate exactly where you would predict. Citation lookups and case holdings, the question's embeddings cannot serve. Here is one per type view that makes it concrete. Of the 50 case holding questions, what did the court decide in a named case? The full stack answered all 50 on both models. Vanilla dense retrieval answered 35 and refused 15. It was not hallucinating. It simply could not find the disposition, because the outcome sits on the last pages, and the case name collides with dozens of others. Deep reading the name judgment at both ends is what turns those 15 refusals into grounded answers. Now, the silent half. Of the 84 unanswerable and false premise items, the grounded systems refused outright 34 to 36 times, and manual coding shows most of the remainder were honest too. Explicit statements that the documents do not say, or corrections of the false premise. The closed book baseline refused 7. It answered the other 77 from memory. Supreme Court holdings, current affairs, provincial rules that no corpus was ever given. That is the benchmark's central contrast. Closed book is not ignorant, it is undisciplined, and a user cannot tell the difference from the outside. Look at the 2 outputs side by side. The closed book model gives a fluent, confident, detailed account of the Panama Papers judgments, with a law report citation. It may even be broadly right, but it is sourced from nowhere the user can check, and the same mechanism that produced this will produce a fabricated holding tomorrow. The production system says, "I don't have that information in our documents." That is the behavior you want from a system that will be asked 10,000 questions you did not anticipate. The other side of calibration is over-refusal, staying silent when the corpus could have answered. For the production reasoning model, it is 5.3%. For GPT-4o, 0.6. And when you look at where the residual silence sits, it is almost entirely in scenario-phrased interpretation questions, the class with the weakest retrieval. In other words, the remaining refusals are retrieval-caused, not policy-caused. That tells you where to invest next, which is exactly what a benchmark is for. Two more results. Language parity. After the translation fix you will hear about shortly, 59 of 60 Roman-Urdu twins matched their English twins outcome on GPT-4o and 52 of 60 on Sol. And model temperament. Sol errs toward caution, GPT-4o toward helpfulness. Crucially, when GPT-4o answers an unanswerable item, manual inspection shows it is mostly being honest in a different register, saying the documents do not state this, or correcting the false premise, rather than inventing, which is why the rubric needed an honesty category. More on that in a moment. Finally, the manual audit. 24 production outputs, stratified across types, coded by hand with the Majesh-style rubric. 21 were correct or better, including 4 grounded non-answers and 3 implicit premise corrections. 3 were wrong, and all 3 were misselections, a plausible but wrong provision, a neighboring section, a different act, and the number that matters most: 0 fabricated citations. Every source cited existed and was quoted faithfully. The grounded system's failure mode is misselection or silence, never invention. That is the property you are buying with all of this engineering. Chapter 6. The part you can apply tomorrow. 7 findings, each discovered by a benchmark question, each turned into a production fix, each verified live. Some of these, to our knowledge, had never been documented for a legal RAG pipeline before. Finding 1. Query rewrite hallucination. The user asked about the punishment for dishonor of a check. The rewrite model, the small step that normalizes the question before embedding, expanded it to under the Negotiable Instruments Act. That is where the offense lives in Indian law. In Pakistan, it is Section 489F of the Penal Code. Both dense retrieval and title affinity obediently steered toward the wrong statute, and the right section sat unretrieved. The fix was a jurisdiction guard in the rewrite prompt, with corrected worked examples. The lesson is bigger than the fix. Hallucination can happen before retrieval, in a stage most pipelines never measure. Finding 2. Neutral citations. A question like, which judge decided 2025 LHC 846 is trivial for a human and invisible to embeddings. The citation tokenizes below keyword length floors and carries no semantic signal. The fix is almost embarrassingly simple. A regex that recognizes the citation pattern, a prefix-bounded exact title match so that 846 does not match 846.1, and then read the judgment's first and last chunks. In the dense ablation, the citation lookup questions are simply refused. Sometimes the best retrieval component is a regular expression. Finding 3. Holdings live in closing pages. A question about what the court held in a named case was being answered from the header pages, the parties, the counsel, the dates, because those pages rank highest for the case name. The disposition is at the end. The fix. When a question names a judgment, deep read the top-ranked match at both ends. But there is a trap inside the fix. Party names are ambiguous. There are several real cases titled Mohammed Rizwan versus State, and judge names put Mohammed into thousands of titles. So institutional words, court, state, justice, Lahore, were added to a stop list so they never count as a match, and the deep read only fires on a judgment matching at least 2 distinctive title terms. That ambiguity is itself a research finding about this corpus. Finding 4 is a meta-lesson, and it is the one I would most want you to remember. The one-line fix for finding 1, Pakistan Law only. Silently broke Roman-Urdu handling. The rewrite model obeyed the newest instruction and stopped translating, so Chori ki saza was embedded as is, and the Roman-Urdu twins refused while their English twins answered. No log, no test, nothing flagged it. Only the paired design exposed it. The fix was to restructure the rewrite prompt as numbered rules with translation first. The standing rule that came out of it: after any change to a rewrite prompt, rerun the language twins. Prompt regressions are silent and cross-lingual. Finding 5 is about scoring. Real outputs force 2 additions to the rubric. Look at this real production answer to the fictional Cybercrimes Act question. It answers from the real statute, PECA 2016, Section 14, with page numbers, and then says plainly that the documents do not identify any Cybercrimes Act 1995. That is an implicit premise correction, correct behavior, which a naive answered or refused count scores as a failure to refuse. The second category is the grounded non-answer. The documents do not state the tariff. Honest insufficiency, neither a refusal nor a hallucination. If your rubric only has answered and refused, it will punish your system for being honest. Finding 6 is an incident, and it is a gift to anyone who runs LLM evaluations. Partway through the production run, the upstream API credits ran out. Embedding calls failed silently. The engine did exactly what it was designed to do when retrieval returns nothing. It refused, honestly, with empty sources. So the run completed, looking plausible, and the first summary table said the system over-refused on 32% of answerable questions. That was wrong. A per-position analysis showed refusals by 60-item window of 10, 10, 13, 19, and then 60, 60. Not a calibration collapse, a dependency failure wearing one. The contaminated tail was identified, rerun after the credits were restored, and the clean over-refusal was 5%. The lesson: positional or time-stamped sanity checks belong in every evaluation harness. A silent failure can produce a beautiful, wrong table. Finding 7 came after the paper was first published, while building a feature that lets readers ask questions about a paper on the website. The request, "Please summarize this paper," went to the rewrite model, which replied with an apology instead of a rewrite. And the apology became the search text, and retrieval found nothing. It is the second failure mode at the rewrite stage after the wrong jurisdiction injection. The guard is simple. Discard any rewrite that is empty, essay length, or refusal shaped, and fall back to the user's own words. 2 different failures at the same small stage, which tells you the rewrite step deserves its own tests. Chapter 7. Publishing. The paper was written as a proper preprint. Title page, contents, numbered sections, references, generated from a Word document so that the PDF carries a clickable DOI and links. 24 hours from first draft to publication. If you do research on your own product, publish it properly. A PDF on your own domain with a DOI is worth more than a blog post, and it is citable. The DOI was registered on Zenodo, free, permanent, and indexed. The record carries full metadata: methods, collection and creation dates, the 14 works the paper cites, and a link to the benchmark repository as a supplementary dataset. A DOI is what turns your PDF into something a journal, a court, or a colleague can cite 5 years from now. And everything is released on GitHub. All 360 benchmark items, the corpus manifest, the scoring and table scripts, the complete per-run results for all 6 systems, including the contaminated run, preserved for transparency, and the paper source. Releasing the benchmark is not just generosity, It is the mitigation for the paper's biggest limitation, which is that the author evaluated his own system. Anyone can rerun it and extend it. The paper also lives on the IrshadOS website, where you can read it online, download the PDF, and ask the system questions about the paper itself, answered from the paper's own text. The evaluated system answering questions about its own evaluation is a small loop, but it is exactly the grounded or silent contract demonstrated on the document you are reading. How do you use this? If you have a legal assistant of your own, run the benchmark against it. The JSON lines file is the input. You log the answer and the cited sources per item, and the repo's scripts score gold source hit, correct refusals, and over-refusal. If you are building for another jurisdiction, keep the 4 design rules. Freeze and fingerprint the corpus. Make every gold label a citable source. Include unanswerable and false premise items so you can test the silent half, and author language twins. And bring the 2 harness habits with you: positional sanity checks and rerunning the twins after every prompt change. What is next? Version 2 brings independent advocate verification of the labels, lexical and hybrid baselines, and more high courts, and the paper is headed to peer review. The limitations are stated plainly in the paper: single annotator labels, 1 high court, a system evaluated by its own author, a bounded manual audit. And one thing this course is not: it is not legal advice, and neither is the system. It is research assistance with citations you can check, which is the whole idea. That is the course. An AI that answers the law should do one of 2 things: cite the text, or say that the text does not answer. Now you have a benchmark that tests both halves, a harness that ablates honestly, and 7 failures you can go and look for in your own pipeline tonight. The paper, the DOI, the benchmark, and the code are all linked below, and you can try the system itself, free, at irshados.com/ask. Thank you for watching. If this was useful, share it with someone building AI for law, in Pakistan or anywhere else.